County Schools in this matter. At this time, I'd like to reserve 3 minutes for rebuttal, please.
3 minutes. All right. You may proceed.
Great. This appeal concerns the Chancery Court's reversal of a termination of a tenured teacher, Mr. Kim Brown, under the Teachers Tenure Act. As an initial matter, there are several areas in which we believe the Chancery Court erred. The first being the factual finding that there was a policy in place regarding preliminary TIM scores. TIM scores are the evaluations that were used at this time for teacher assessments. And we do believe that there was, in fact, no policy regarding this. It was statements made by one witness that were then contradicted by the same witness, and another witness also indicated she did not have knowledge of that policy. There's also no policy contained in the record on this issue, despite the actual dismissal policy being in the record. In addition, even if this non-policy or practice was to be considered, we think the Chancery Court also erred in failing to determine what the proper time of termination was. We believe termination can only be done by the board as is statutorily required. However, the time at issue in the Chancery Court's ruling involved the election, the non-re-election recommendation made by the principal, not the board. Secondly, we take issue with the Chancery Court's determination regarding a policy that would have required us to do what is referred to in the order as an individual growth plan. There is also no evidence in the record regarding a policy of this type as well.
Is that a defined term?
So it's referenced in a case called Harrison. It's a 2018 case, I believe. And it actually, there is a policy that existed in Shelby County the year prior to the year at issue, but there's been no proof that it was applicable at this time in this case. That policy has not been submitted into the administrative record at any point. So to the extent that the individualized growth plan is a term of art, that's what it was referred to in Harrison. We would submit that the actual essence of Harrison is that there is just some sort of professional development provided to a teacher prior to termination, which we believe was done in this case through Mr. Brown's participation in what is referred to as the PAR program.
Well, the reason I asked that question is because from my review of the record, there was assistance provided.
Yes, Your Honor, quite a bit of assistance.
And I'm trying to distinguish what an individualized growth plan is, how that's different from providing assistance. So
your guess is as good as mine, Your Honor. That's kind of the essence of our argument, that we think the fact that such a great deal of professional development was provided to Mr. Brown prior to his termination, it's just 6 of one, half dozen of the other in that sense. So that's our position. As it pertains to additional errors by the Chancery Court, we do think that there was a failure by the Chancery Court to consider a great deal of evidence that went to the definitional inefficiency ground, which is a wanting of effective performance of duties. This is an entirely separate heading in the hearing officer's analysis. However, the Chancery Court did not provide any insight regarding this particular wanting and effective duties prong of inefficiency. We would submit that that's a totally separate and independent way to prove inefficiency, separate and apart from the TIM score analysis, which was addressed by the Chancery Court. Finally, there...
Do you have a final judgment if, in fact, that is the case?
Excuse me, Your Honor?
Do you have a final judgment if that, in fact, is the case?
Well, I would say we do. Well, I would say, Your Honor, in a de novo review, given that the standard would be to determine whether there is a preponderance of the evidence to support the termination decision.
Your argument is the Chancery Court only considered one prong of the findings that allowed the county to terminate. So there's another prong out there outstanding that's yet to be ruled upon by the Chancery Court, correct?
I would say it's actually within, given that the de novo review, since the review was different for the Chancery Court, it's not a typical review like it would be if there were.
Chancery Court reviews it just like the appellate court does.
Yes, Your Honor, I believe so. But I do think that the fact that the decision was not fully embraced, I mean, I guess you could remand on that basis if you wanted to do so. However, I do think it would be more appropriate for the appellate court to address the issue, given that it needs to review the preponderance of the evidence anyway. I do think that that would be a more effective and efficient method of doing it, given that the trial court's decision would have pretermitted that. Well, I agree. I argue that it would not have pretermitted. They should have addressed it anyway, and I think it would have affected the reversal. I think it would have been the hearing officer's decision would have been affirmed had that been looked into. So to the extent that Your Honor feels we need to remand for that.
I'm just asking a question.
Well, I think that would be fine with us because we think there is a mountain of evidence that would support that prong, as the hearing officer also found in this case. There were multiple instances in which witnesses testified at the hearing regarding the chaos that was consistently taking place in Mr. Brown's classroom. He was witnessed screaming at children. At one point, he even had to apologize to his PAR mentor for yelling at a second grade student. He's described as having a verbally aggressive tone with students, and his overall classroom management skills were not such that the students could properly learn in the environment. Because of that, we do think that that was a basis for wanting an effective performance of duties, especially given that there was also testimony adduced in the administrative record that almost all of his students, I think it was nearly 100%, were not proficient in their levels. So based on that, I do think that the Chancery Court did err in not addressing those issues and not giving a full review of what it should have done regarding the different bases for inefficiency that the hearing officer found.
Let me ask you a question, and Mr. O'Neill, I'll give you the heads up. I'm asking you the same question, and that's what purports to be a pretty simple question. As I understand the chronology here, we had the hearing officer conducting the hearing, making a determination, rendering an opinion. Then there was an appeal to the commission, Board of Education. At that time, the appellee failed to appear and essentially failed to contest that finding. What does that do to us procedurally as far as what we're looking at and what opinion is actually being, what we're having to analyze on appeal?
So even though Mr. Brown did not appear at the Board of Education hearing, it did take place. It did affirm the hearing officer's decision. So to the extent that the procedure and the appeal to the Chancery Court took place as the scheme allows, I don't think that would have an effect on what we're doing here today, given that the board did actually reach a decision affirming the hearing officer. However, we did have issues initially regarding Mr. Brown's failure to exhaust his remedies in the administrative proceedings. We have since withdrawn that argument as it pertains to
that
agencies.
may have resolved the issue.
Okay, well, good.
But I'll still let Mr. O'Neill tell me about it.
Okay. I will also add there was an order of back pay entered in this case. We have a lot of issues with the back pay order. Back pay was not sought or requested or proven at any point in the administrative hearing. Mr. Brown did request reinstatement, that he was represented by counsel at that time. He was able to put on proof. We provided 4 witnesses. He provided 3. He took the stand himself. At no point did he ever testify about what his salary was. At no point did back pay come up at all in the administrative proceedings. Reinstatement did, so he was requesting that remedy. The first time back pay is actually requested was before the Chancery Court, and we would submit that that's actually not a proper award that the Chancery Court then made because of the failure to request it in the administrative proceeding. Further, because of the gaping hole in proof regarding back pay, there was no evidence. There was nothing that the Chancery Court could have done to have ruled regarding the back pay. So instead of rendering zero back pay because there was no evidence of it, the Chancery Court then remanded the matter to the Shelby County Board of Education, which is lay persons that are designed to serve as an appellate tribunal in this case, and then required an affidavit be submitted to him or submitted to the court so that he could make a ruling regarding back pay. There was a lot of back and forth regarding this, but we submit that that was entirely improper, given that a remand would not be appropriate, given that there's no arbitrary and capricious finding, and that it was also not appropriate for the chancellor to have considered any evidence outside of the record. So
let me ask you, in these tenure cases where the teacher is able to get the termination set aside, obviously under the statute, they're entitled to back pay for that period of time that they didn't work. In the past, how has that been done by the court? Hasn't it been referred to the school board to make a determination about what that pay would be?
we were not provided with any authority from Mr. Brown's side, and I personally, in my research, have not seen where there was an actual remand by the trial court to the school board to do that, that we've come across, and we've not been provided any. However, I think that issue is actually pretermitted by the fact that it wasn't even requested in this case, where in much of other cases, I'm sure there would have been relief sought for back pay. Here, it wasn't even sought in the administrative proceedings. And that issue could have been easily cured if Mr. Brown had simply testified at the proceeding, oh, my salary is X. Then there would have been proof for the trial court to have been able to assess back pay. However, since that evidentiary finding was not in the record because it was not sought, we would submit that it would not be, the remand was not appropriate.
So to your knowledge, in connection with these tenure cases where the teacher is successful, the proceedings have never been bifurcated, where you would address the amount of back pay in a later hearing?
That I have seen personally, Your Honor, no. I don't know if there are cases out there. However, in your Telly White decision that I believe you issued in March of this year, and I believe my time is up if I may continue answering your question. I do believe Your Honor even referenced that remands are typically not appropriate unless there is some sort of judicial finding regarding a procedural defect or an arbitrary and capricious finding, or that the record is incomplete or flawed in some way. I would analogize that to something to the effect like an appellate record missing a pleading or something like that.
That was not a tenure case, though, was it?
Yes, Your Honor, it was. Yes, Your Honor, it was the football coach that had been fired due to changing grades.
Okay, all right.
And if you don't have any more questions.
Used your time.
Thank you, Your Honor.
I don't know why these people are asking all these questions.
It's a hot bench.
It's pretty cool in here.
There you go.
Now, you know, Mr. O'Neill's sitting down there, he's just waiting.
Good morning. If you may please the court, my name is Darrell O'Neill. I have along with me co-counsel Laura Smittick, and we represent the appellant, Mr. Kim Brown. We respectfully request this court to affirm the decision of the trial court. And I got about 6 reasons. I'm not going to reiterate my brief because you read it, so I'm not going to waste your time. But let me start off with Judge Stafford's question. You know, Judge Stafford, you said the fact that he didn't show up at this hearing, how did that affect the decision?
That was my question.
We submitted it had no effect on the decision. For the first time, that's today, the school board now says it has no effect. So let me walk you through this, Your Honor. The first thing in this case was the notice. That's in volume 11, exhibit 6. The notice says inefficiency, and then it says examples of actions, and it says the 2 TIM scores. So that's what it says for the notice. But you know how we know that the only thing they were arguing about in this case was the TIM scores? Cheryl Estes, the lawyer who was representing the school board, said it. For instance, volume 10, transcript, page 61, Ms. Estes, and I quote, specifically says, again, that's totally outside the scope when you're dealing with a teacher tenure hearing regarding their issue with determination based upon the evaluation. That's the 2 things that they're charged, the evaluation. The sole issue that are before the board deal with the scores that are given or the proper amount of the observations conducted if the scores are accurately reflect and are consistent with board policy. That's page 61. And page 62, she goes on to say, in addition, we also, as shown from the testimony of Ms. Branch, go through the process to show that all due process was given to the teacher that's required under both state law and is consistent with board policy. Anything beyond the process is not admissible, nor is it to be considered in dealing with the teacher's dismissal hearing based upon evaluations. Their whole argument at the board level was about the evaluations. That was their whole argument. For the first time, we're talking about something different. Your Honor, this is a case of litigation remorse. And here's the reason why I say that. They filed a memorandum to the court. And in their memorandum, here's what they did. In our memorandum and a petition for writ of cert, we asked.
Is this in the record?
It's in the record.
Okay.
And I'm glad you said that, Your Honor. I'm sorry, I got ahead of myself. It's volume 3.
I can't imagine that, Mr. O'Malley.
It's volume 3 in the record, page 390. And this is our petition in support of writ of cert. We made 3 reasons why the court should reverse in our favor. Number 1, we said Shelby County Schools initiated termination proceedings against Mr. Brown without sufficient grounds. That's number 1. We said number 2, Shelby County failed to follow its own policy and terminate Mr. Brown. Number 3, we said Shelby County intended to terminate Mr. Brown regardless of the rationale. Then the school board responded to that. Here's their response. They wrote a brief that was 16 pages. And of that 16-page brief, 14 of the pages was about Mr. Brown had waived all his rights and the UAPA applies, and because the UAPA applies, Mr. Brown shouldn't even be here. Specifically, volume 3, page 410 of the actual appellate record, it says, first, under Tennessee law, this is the school board's writ of cert. First, under Tennessee law, the board's judgment on petitioner's appeal rendered in his absence and therefore on default by the petitioner constitutes a dismissal of all claims. That's their first argument. Their second argument that the petitioner impliedly waived the right to appeal by failing to appear at their hearing before the board. That's the same question you had, Your Honor. They raised that in their argument. The third argument, they said, third, the petitioner was required to appear before the board at his hearing to sufficiently exhaust his administrative remedies before the petitioning this court for judicial review. That's the argument they raised. The first time they say, oh, we're not proceeding under that argument was today. That was what they argued. We filed a reply. In our initial writ for cert, we requested back pay. They didn't even respond to that. If we want to talk about waiver, it's the school board's waiver. When they started this case off, they said it was Tim's evaluation was the sole basis of Mr. Brown's termination. Then they changed. Their own counsel said, we can't talk about anything else other than the evaluations because that's the whole sole reason why we're here. Then, when we get to the court, when we get to Chancery Court, they don't even talk about any of that stuff. Their 16-page breach, and I challenged the court to read it. You probably already read it. Their 16-page brief, 14 pages of that brief is about how the UAPA applies, and because the UAPA applies, that Mr. Brown is not even entitled to be before the court. Then when we go to hearing, they said, my fault. The UAPA doesn't apply. This is a statutory case, so it doesn't fall in the UAPA. That's the real answer to your question, Your Honor. Statutorily, this case will never fall in the UAPA because statutorily has the appeal process for this particular case. And just to answer your question, Judge Armstrong, the same issue with back pay is statutory. The counsel said that I have never told them what cases. I beg to differ. We cited Mumford, which stands for back pay. We cited Harrison, which stands for back pay. We gave them 10 cases that cited back pay that you don't even have to request it. Under the statute, it's automatic. reinstatement, back pay goes with reinstatement. It's statutorily. So then the chancellor has to rule. So the
What
chancellor.
about the chancellor's ruling? Opposing counsel says, and it seems to be that the hearing officer found at least two grounds for termination, and the chancellor only addressed one ground.
She did not. She only found inefficiency based on temp scores. That's all she found. And specifically, what she stated in her argument, in her ruling is, she started saying it was observation. The second grounds was observation. The observation was part of the temp scores. So basically, it was classrooms observations. So that was the second part of it. So then, in her ruling.
Well, let me read you this.
Okay.
Even if, however, Mr. Brown were not charged with his final scores and was able to hang his hat on his preliminary score of a 10-3 for 2012-13, Mr. Brown's overall classroom observation scores were below expectations on both his preliminary and final evaluation for school years 2011-12 and 2012-13. Mr. Brown would therefore be deemed inefficient as a matter of law pursuant to the statute.
Yes, Your Honor.
Seems like a pretty strong finding to me.
It is. But you fail to understand that observation scores is part of the TIMS. So the TIMS evaluation has a number of prongs. It has students portions, it has observations, and then it has the grades that comes back from the testing. Classroom observations was part of the TIMS score. And in fact, that's what happened in the Elmy case. In the Elmy case, she was terminated she had TIMS scores that the actual classroom grading scores had never came back from whether the students take tests and things like that. That had never came back. And so they based her termination on observations, classroom observation. That's the second part of the TIMS. This court in Elmy says you can never use observations as a basis to terminate a teacher. And in fact, I'll re-quote for what this court said in Elmy. What the court said in Elmy is that the Tenure
Which
Act.
case is this?
Elmy versus,
Okay.
It's Elmy versus the Cheatham County School Board.
2017.
It 2017, yes. And in Elmy, what the court says, the Tenure Act defines inefficiency as having evaluations demonstrating an overall performance effectiveness level that is below expectation or significantly below expectations as provided in the evaluations guideline adopted by the State Board of Education pursuant to 49-1302. And then it goes on to Tennessee Code annotated 4955016. Thus, the definition itself makes clear that inefficiency is to be determined based on evaluation demonstrating an overall performance effectiveness. Nevertheless, the board apparently seeks to modify the statutory definition, here we go, by basing inefficiency on the classroom observations. That's the second part of what the hearing officer said, the classroom observations by the school administration. We believe this is contrary to both the letter and the spirit of the Tenure Act. This came from the Court of Appeals. That's what this court said, that classroom observations cannot be that basis. And that's the second part of what the hearing officer said. So to answer your question, when she said his observations, she was talking about his classroom's observations. And the Court of Appeals said that cannot be a basis for termination under the tenure statute. The other part about that is they never addressed back pay in the original argument. They never addressed back pay. They filed a motion to alter amend. In their motion to alter amend, they never addressed back pay. For the first time in their motion to alter amend, they started bringing up cases and started talking about things that they should have raised in their original argument, which they never did. So the trial court specifically addressed that issue with them. The trial court went through it with them and says, and page 494 of the appellate record, volume 3, and it says at page number 37, the court says exhibits 6, 10, 12, and 13 were all in the record and available prior to the initial hearing in this matter. So on their motion to alter amend, they started talking about all these other reasons why Mr. Brown, for the first time, after we've been in the court all this other time, now they're raising in the motion for alter amend, they're now raising to the court, hey, Your Honor, nobody considered Exhibits 10, Exhibit 6, Exhibit 10, Exhibit 12, or Exhibit 13. And the court said, wait a minute. Those were all in the record during the original case. Why didn't you bring that up in the original argument? No reason. Gave no reason for that. Then the court said, well, I'll go look at them anyway. So the court said, let me look at them for you. And then the court goes into it, page 493 of volume 3 of the record. It says, paragraph number 32 rather, it said, Exhibit 6 is a copy of the letter listing the charges directed towards Mr. Brown, dated October 15, 2013. This document shows the charges against Mr. Brown was inefficiency. Page 494, paragraph 33. Under section 2 of the letter provided examples of actions that supported the charges of inefficiency. The only examples listed were Mr. Brown's 2011, 2012 TIM scores and his 2012 and 2013 TIM score. There was no mention of any other actions by Mr. Brown supported in the finding of inefficiency. It says Exhibit 10 is Mr. Brown, paragraph 34. Exhibit 10 is Mr. Brown's 2012, 2013 TIM score. Exhibit 10 didn't have any additional information that supported a finding of inefficiency independent of Mr. Brown's TIM scores. Paragraph 35. Exhibit 12 is Mr. Brown's 2012, 2013 Notice of Non-Reelection. This exhibit states that upon review of his file, Mr. Brown was recommended by the superintendent for non-reelection and that he would not be informed for final decisions by June 30th. Then it goes on. There's no mention in Exhibit 12 of any actions by Mr. Brown that supported a finding of inefficiency independent of Mr. Brown's TIM scores. Paragraph 36. Exhibit 13 is Mr. Brown's agreement to participate in the voluntary peer assistance review program. And it says there is no mention in Exhibit 13 of any action by Mr. Brown that supported a finding of inefficiency independent of Mr. Brown's TIM score. Your Honor, with all due respect, they didn't raise any of these arguments in their initial petition for writ of cert. For the first time today, they are now telling this court, my fault, the UAPA, we really wasn't proceeding under that venue. Again, as I stated when I first started up here, this is a case of litigation remorse. If a plaintiff goes and tries their case and fails to present evidence and then find out later on, oh, I should have put this evidence forward. You don't get a do-over. They're asking for a do-over. They had the trial, they had the opportunities, they chose not to do that. This court told them to remand it to the back pay. This court told them to do it, they didn't do it. This court told them to do it at least 3 times and they didn't do it. What else can you do? Your Honor, for all the reasons in my brief and all the arguments today, I respectfully request this court to affirm the decision of the trial court. Thank you.
Thank you. Ms. Deakins, I believe you have 3 minutes.
Thank you, Your Honor. I'd like to address some of the points brought up by Mr. O'Neill. The first of which indicates that we did not previously notify the court regarding the administrative remedies. As seen in the first page of the Chancery Court order dated February 12, 2019, it states preliminarily, Shelby County Schools has conceded that the issue of exhaustion of remedies by the petitioner is moot and the issue will not be addressed further. So since 2019, that's been a non-issue. It's not new today. Secondly, to the extent that Mr. O'Neill has indicated that we never raised the issue of inefficiency based on anything other than the TIM scores, that's patently incorrect. As the notice of charge that Mr. O'Neill referenced, which is, I believe, volume 11, exhibit 6, it clearly states that inefficiency is the basis for this termination, states the statute site, and then states for the reasons including but not limited to, and then lists the TIM scores. So it was a non-exhaustive list provided. We would be unable to put all of the different inefficiencies that we believe Mr. Kim Brown had in one charge. So what we did is presented our evidence at the administrative hearing. That's what you do. The hearing officer agreed with us that there were multiple methods of finding Mr. Kim Brown inefficient, and actually the quotation that Judge Stafford read off, the very next paragraph is an entire section devoted to wanting an effective performance of duties. That's exactly what the hearing officer found. That was raised at the administrative proceeding. To the extent that Mr. O'Neill attempts to argue that we did not address that before the Chancery Court, there's no transcript of that hearing, unfortunately. What we did do is do a statement of evidence. In the statement of evidence, it clearly states that our primary argument is that the evidence is not preponderate in favor of the trial court's ruling regarding the reversal of the termination. That would include the ground for inefficiency on any reason, as the notice of charge set forth. So
About
to the
Elmy then, what Mr. O'Neill says, Elmy says you can't do it the way you're wanting us to consider doing it.
So that's actually he was right that actually goes to the TIM scores, and there was a lot of confusion in the law at that time. It's actually even referenced by the hearing officer herself regarding what the term evaluations, plural, meant in the statute. That went to the TIM score, as Mr. O'Neill stated, and the observations were part of that. We are not relying on that. We are relying on the final TIM scores, and then a totally separate basis that has nothing to do with observations, but it just has to do with his bad classroom management skills, his failure to implement suggestions, his failure to control his classroom in any way. So I believe my time is up, but if there's any other questions, I'll be happy to address them.
I see none.
Thank you, Your Honors.
Thank you for your argument, both of you. We appreciate you joining us today, and we will take this matter under advisement and attempt to render an opinion at the earliest possible time. We'll be in recess to the call of the docket this afternoon.
All rise.